I just joking.
All right, I've got 9 o'clock. We will call the Commissioners Court to session, which is scheduled for October 12th today at 9 a.m. If you'll stand, I've asked Commissioner Langford to do a revocation if you remain standing for our pledge.
Dear Heavenly Father, we thank you for a beautiful day that you blessed us with. And we thank you for this time to come together that we may do business for Montague County and do it to the best of our ability. Pray, dear Lord, that you be with Commissioner Murphy that's not here during his illness. I understand he's having a pretty rough go. Please be with him. Thank you, dear Lord, for all the blessings you've given us. Pray that you just be with military men and women and the police and all the sheriffs and everyone that tries to keep this country safe. Pray, dear Lord, that you let us lead, guide, and direct us and forgive us for many sins and shortcomings. I ask this in Jesus' precious name. Amen.
Amen.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to the Texas, one state, under God, one and indivisible.
Takes us to item 3, which is public comments. Do we have any public comments? No public comments, so we'll move to number 4, which is our consent agenda. Consent agenda includes non-controversial and routine items that the court may take action with one single vote. The judge or commissioner may pull any item from the consent agenda in order the court to discuss and act upon it individually as part of the regular agenda. And on that is A is the approval of minutes, and B is the examine all accounts and reports relating to finances of the county. C is audit and settle all accounts against the county and direct their payment. And D is approve the payroll.
See, the judge, I'll make the motion to approve the consent agenda then.
Second. So we've got a motion by Commissioner Langford, a second by Commissioner Mayfield. Any discussion? All in favor? All voted for. All right. So we'll go to number 5. Discuss and consider a line item budget adjustment to correct the fiscal year 2021 budget for the district attorney's state salary benefits and take necessary action. And I think Autumn's going to speak to that.
Yes, in the new software, his retirement, social security, and healthcare are coming out of the DA's general fund. And we've always transferred that money over there. They're coming out of the general fund, so we need to cancel the transfer. And that way it'll be billed correctly to the other 2 counties. So it's a wash, it's an even wash. There's no change on this one.
This is it, what's on the documents, isn't it, Jennifer?
Yes, sir.
Retirement. Judge, I'll make the motion to approve the line item budget adjustments to correct the fiscal year 2021 budget for the district attorney's state salary.
So I've got a motion by Commissioner Langford. I've got a second by Commissioner Darden. If we have any discussion, all in favor, all voted for. Item 6, discuss and consider the HAVA grant, a transfer of remaining funds and take necessary action. And I'll call on the auditor again.
This one is the remaining balance of the $18,000 grant that Ginger got at the very beginning for the voting. There is a list attached of the funds that she has expended, and that is from Ginger and Charlie. And we're just asking that the remaining funds be moved from the general fund to the grant fund that Charlie is tracking all this through, and that will have to come from contingency. But those are grant funds that need to come out of the general fund.
This 510163.
Yes.
Contingency to the grant fund.
And that's because it was not spent last fiscal year.
I'll make a motion for that, Judge, to move $5,101.63 from contingency to the grant fund, I guess, in the elections office.
For the elections office, yes.
Second.
Do we have something that has that 51,000?
It's 5,100.
What is it again?
$5,101.63.
Okay, thank you.
So I've got a motion by Commissioner Langford. I've got a second by Commissioner Mayfield. Is there any discussion?
I think I got it.
Are you sure? Okay.
I have copies for you, Glenda, if you
Thank
need them.
Okay, any further discussion? All in favor? All voted for. All right, item 7, discuss and consider approving the 2021 Montague County resolution for the Indigent Defense Grant Program and take the necessary action. From what I understand, this is our grant that we fill out every year, where we get funding to reimburse us for court-appointed attorneys for defense in our courts. And this is coming out of Court of Criminal Appeals. And I would have to have authorization to sign this.
Yes, you and the county clerk both.
Correct.
Put that form of motion to approve the 2021 county resolution for the Indigent Defense Grant Program. Give you the authority of the clerk to sign it.
Second.
So I've got a motion by Commissioner Langford. I've got a second by Commissioner Gordon. Any additional or any discussion? All in favor? All voted for. Item 8, discuss and consider approving the memorandum of understanding with the Abilene Regional Council on Alcohol and Drug Abuse Incorporated to take necessary action. Now, on this item, the Abilene Recovery Council apparently contracts with Helen Ferry. It requires that we agree to this. Again, I think it's an annual agreement. And again, I believe I will have to have authorization to sign.
I'll make that motion. We accept that agreement and give you authorization to sign it.
Second.
All right, so I've got a motion by Commissioner Mayfield. I've got a second by Commissioner Langford. Do we have any discussion? All in favor? All voted for. And then along with this, number 9 is discuss and consider approving the memorandum of understanding between the county judge, the Justice of the Peace Precinct 1, Precinct 2, and Helen Farabee Center Substance Abuse Services and take necessary action. And the purpose in this, if you look at your printout, it says make appropriate referrals of clients to the HSC Substance Abuse Services, maintain ongoing contact with Helen Farabee Center Substance Abuse Services, and acknowledge and abide by the Helen Farabee Substance Abuse Services confidentiality policies. And basically this is, like I say, between both Justice of the Peace offices and the county judge's office for people that would be sent to these facilities.
Put that in form of motion, Judge, to approve the memorandum between Montague, between the county judge, JP1, JP2, and Helen Farabee Center's Substance Abuse Center. Give you the authority to sign any necessary documents.
Second.
So we've got a A motion by Commissioner Langford. I've got a second by Commissioner Mayfield. Any discussion? All in favor? All voted for. All right, item 10. Discuss and consider approving a proposal between Montague County and ComCell and take necessary action. And I think Mr. Humpert is here. We've had a meeting, myself and Mr. Riddle and Kelly McNabb, who is our emergency management coordinator and works with our towers. There should be a contract in your packet. Mr. Humpert with ComCell is asking permission to put a antenna on our county-owned tower that is located out here by Hildreth Pool. In their contract, what they're proposing is to pay us $400 a month rent to place that antenna on that tower. Of course, with the contract guarantees that it will not interfere with anything that we are currently using up there.
Do we know if that's a going price for something like that?
I think actually we've looked at what ComCell is paying some of the other counties, and I think actually that's a little higher than we're paying some.
Good.
And Mr. Humbert, you're welcome to speak if you wish, but
I'm just here if you guys have any questions. And I guess a lot of it has stimulated this because of the COVID. It's crazy because the fiber businesses went just out of sight, as y'all probably know in this area. And the government did release some 5.9 frequency for us to use, but it doesn't reach out as far. So we've got customers that are in really need of this. Plus, we hopefully will pick up more customers. And with the possibility of we're doing fiber in Henrietta and Bowie, that we're looking at starting to extend down 59. So there's a good chance, in the future, we could have fiber to that tower if you guys need it, or even come into this area and help offset some higher prices of fiber and wireless internet. So it would be a wireless internet that we're doing. And our company is out of Windforce.
And so in addition to paying the county for the rent of the tower, I think we're providing our citizens for access to a product. So.
Opportunity anyway. It's a 5-year deal, looks like here.
Yes, sir.
I make a motion to approve the contract between Montague County and ComCell and give you the authority to sign all documents.
Right. All right, so we've got a motion by Commissioner Langford, got a second by Commissioner Darden. Any further discussion? All in favor? All voted for. All right, we'll move to item 11. Actually, 11, 12, and 13 will all in a way be connected. So we'll start with 11, which is discuss and consider revised Montague County personnel policy and take necessary action. A lot of this, the majority of this is to get us in compliance with state and rules and tax regulations. And I'm going to ask Jennifer if she wants to speak to the changes that we're proposing, or the additions, I should say, probably would be more accurate.
The main thing, the biggest thing that's going to affect everybody is, do we want to include drug and alcohol testing, pre-employment, post-accident, and reasonable suspicion for all employees? Or do we just do that for our DOT regulated CDL drivers?
Yeah, by law, all of our commercial drivers have to have a pre-employment test. Okay, they have to have a random test. The choice we have is, and I believe the sheriff is already obviously doing pre-employment tests on his hires for law enforcement and jail. And so what that leaves is the balance of county employees. If we wish to do a pre-employment test for anybody hired by Montague County, that's a question. Otherwise, like I say, as far as CDL and et cetera, that's a mandate.
What's it cost? What was the cost?
We've got, and actually, we're gonna get into that in the next one, but let's talk about it now.
It's $400 or $500.
I think the cost per test is $30. Is that, am I accurate?
35 for the lab, but for an instant test, it would be 28. The instant is just a little dipstick that we put in and we get preliminary results. But the lab would actually be collected and sent it out to the lab where it's screened and confirmed if any medications or anything come up.
And you are Amy Hanley.
Yes,
Ms. Hanley is here with Drug and Alcohol Testing Compliance Services out of Wichita Falls. If you recall, we had, in one prior meeting, we had two different companies that showed up to speak to us and showed interest in our testing. Since that time, I think that through communications with our treasurer/HR department, this company is the company that responded and appears to be working with us, which we'll get down to that in our next item. But right now, I think we've got a couple of questions I have. When you get in this policy manual, one of the things that I really think we need to probably add in having meetings with the HR under D, and I'm sorry, I don't have any page numbers on here, so I can't direct you to a page. But under D, which is safety and health employee responsibility, on that bottom paragraph, it says any employee who suffers a job-related illness or injury is required to notify his or her supervisor as soon as possible. Failure to promptly report job-related injuries or illnesses may affect the employee's eligibility for benefits or delay benefit payments. What I've mentioned to Jennifer is that to the treasurer is that probably should be expanded slightly, and that those reports should also be made to HR. If they're made to a supervisor and it dies right there, then when they try, if they're hurt, or let's say they've had an injury and they don't think there's a lot to it, and then 2 or 3 weeks down the road, they begin to suffer consequences from it. If it hasn't gone through our HR department, when workers' comp gets involved, they can deny that claim if there isn't proper notification. And so really under that section on that paragraph, I really think that should be expanded slightly to say that obviously they need to report it to their supervisor, but it should also go on to say that they have the requirement to report that to HR. And when they do that, HR will have a form that's an incident accident report form. If they have something minor and it doesn't turn into anything, all that does is that form just simply goes in the file and ends right there. In the event that something further happens, then it has been filed.
I agree with that.
Yeah, I think it does, because that's where it needs to end up in the HR department, so they can keep track of everything in the county.
In going through this, again, I'm sorry, I don't have page numbers, but if you turn to like 3 pages past that, which you'll see is under 1D3, drug and alcohol, all employees. The first page where you see highlighted items, if you're at 1, 2, 3, about the 4th paragraph down, under suspicion-based testing requires supervisor training. It says under the influence shall be defined as having blood alcohol concentration of blank or more. And in my opinion, any is too much, okay? And so I think that in our policy manual, I don't think any employee should test positive for any amount of alcohol if they're working, is my opinion. Now, I think that this stuff from tax says the county can choose anything from 0.01 through and including 0.08. So I guess if that's our only option, I guess we would go, in my opinion, with the lowest rate. If we can't do 0, then I guess 0.01 would be my opinion. Although I prefer 0.
I think you run into issues because I don't think that's, there's no presumption that I'm aware of as far as what an employer has. So I suppose the employer can set whatever they want. It's just an interesting question because it's not illegal to drink and drive. It's illegal to drive intoxicated.
But this is our policy.
I understand. That's why I agree that it's whatever you guys decide to make it.
With the least amount, that makes sense to me. It makes it pretty simple right there. You stay with that. Because that's what they're
If we really,
recommending.
and as they say, we can only choose from that, so. So we'll have that to fill in once we vote. Also, and you move on back under 2A11. Never mind, I think I've got that answered. I'm sorry. We'll move on. I've already marked it. I don't have a question. Your very last page, 2B13, leave of absence -other. Employees may request a personal leave of absence to a maximum of blank days. And then it goes on and talks through that paragraph about leave of absence. And I guess the question is, do we want to allow an employee to request leave of absence? And if so, what amount of time? To me, what is reasonable would be the same amount of time that they would receive if they were on FMLA, which is 84 days. There's some places that you can do 30 days or greater. But that's something that we will have to decide and fill in.
FMLA is 84, did you say?
12 weeks of FMLA, unless it's to do with caring for a veteran or someone that's in our military. And I think it needs to be 26 weeks. Or you may not want to allow leave of absence. It's just,
Well, I think and that, I don't guess that's ever been a problem, really, anybody, but it is an option. You just never know what might happen that a person needs to take a leave of absence. I like the idea of the 84 days, 12 weeks.
Yes, sir.
That way it keeps it all the same. Pretty simple that way. I'm good with that.
That. And is there more? Is there anything else I haven't marked that we had questions on? Go ahead.
Is it in there, Jennifer, about the drug test? I know at one time we talked about all county employees, and we come to find out TAC does not allow that. It's CDL drivers.
You
Random.
can't random test all employees. You
Yeah.
can do pre-employment, post-accident, and reasonable suspicion
Yeah.
on all employees. And that's what I'm asking, do we want to include all employees in those? Or do we want to just contain our drug and alcohol testing to our CDL employees?
And does that, I think, correct me if I'm wrong, I think that's addressed in item 13 in our, or am I wrong?
We have to make a call on that before we can move on to the drug testing, I think.
Yes.
We
Yes.
can move 13 in front of 12.
Well, however you want to do it. My deal, and I know we've talked about that, if this county was a great big one, maybe we do, but to my knowledge, in the past 25, 28 years, we office holders really hadn't had, it's been CDL if there's been any problem. I'm for keeping it as simple as possible, all just the CDL drivers, all the drug testing goes for them. If an office holder suspects that they've got a problem in the whatever office, I think they could deal with that fine.
But if we don't have it in our policy,
That they could, if it's just a suspicion,
if we don't have it in our policy,
they can't do it.
they cannot do it.
But just to leave it up to the supervisor in the other offices, however we need to put it in the policy, Jennifer, is great to me, to make it law abiding, but what are you talking about for the office, like your office? Take your instance. I don't think that you need a pre-employment random test in your office. My deal is, I think if you suspect sometime during one of your employees is doing drugs and you want to call a drug test on them, whatever it needs in the policy manual to cover that's what I think needs to be done.
And I can speak to that just a little about it. We cannot do random tests on anybody except CDL. We're limited there. So any random testing is just CDL, and we have to do that. We have no choice. We don't even have the ability to ask for any other employees to do random. Post-accident, obviously, we've got somebody in a county vehicle or somebody that's even in their own vehicle, but they're doing county business and have an accident,
Yes.
probably needs to have a post-accident test. My opinion.
Is it limited to a vehicle? What if they just have an accident on the premises and
I think, and say that again,
what if they just have an accident on the premises, not in vehicle related, but have a fall or whatever? I mean, if you got somebody stumbling around, they fall and they want to sue the county, I mean, we could put a drug test on them. That's what we did in the oil field, is it did have to be related to the vehicle, be on site.
and I think we're probably talking about two different issues. I think if you as a supervisor think that if they're stumbling around in the yard and they fall and get hurt, and you at that point believe, you see some suspicion that makes you think that they're intoxicated or on some controlled substance, then I think we fall into the other category, where then you send them down and get them tested.
But it's gotta be in the manual, right?
Yeah, we need to spell this out. And basically that is, we're kind of,
That description there is in the manual.
we're gonna get into that, yes, sir, and the other part of it. So I guess we can jump around a tad. Each supervisor is gonna be required to go through 2 hours of training. Now, once that's done, TAC will furnish that training, and with all of our COVID issues have said that they will do it virtually for us. So every supervisor's got to go through 2 hours of training, and that will then qualify you to be able to say this person appears to be under the influence, or you believe they could be. I think once before it was discussed that we've got law enforcement that are already trained to do that. And I'm going to tell you, I'm opposed to that, because if you think you've got an employee who is under the influence of some substance, when you go to them and say, you're going to have to be tested, that's an internal situation, and you can force that on them. You can tell them that's a condition of their job. They can either get tested because they meet this criteria, or they could lose their job. Now, if we put law enforcement involved in that, let's say that on the back side of that, it grows into a criminal offense, all right? If we've done something where we've got law enforcement involved on that front end, and we have forced them to provide that sample through law enforcement, then they can no longer use that. And so my opinion is we keep law enforcement completely out of that realm, just in the event that they would have to come in and do a criminal investigation.
Yeah, so if we need to do that.
Correct.
I'm good. We get it worded in policy just like that.
I'm for the pre-hire employment test too, because I mean, it's not gonna be that many people, we're not gonna go in here and drug test everybody right now, but anybody gets hired before.
So you are in favor of,
I'm for it, because I mean, that could eliminate for 30 or 40 bucks, we could eliminate a big headache that comes up that
I agree with that.
you can't see.
In any office,
any office.
Well,
I mean, it's new hire, there ain't gonna be that many people.
you know, I'm good with that too. It's just in the past, I don't recall ever having that problem.
It would probably never will, but it's pretty cheap insurance.
It's consistency.
Yeah.
It's
Just
treating
do it all.
everybody the same.
That way, if somebody did come in and messed up, we could end it right there before it. And it ain't gonna cost the county much money to do it.
As long as we can get this in that personnel policy and quit having to worry about it. This thing been dragging on for a long time.
I agree, we need to get in compliance.
Does it identify exactly what it tests positive for, and then what's the criteria to test positive for this? You're not hired, if you test positive for that, you are hired, I mean,
I think
and what
that,
concentration levels?
I think that, well, and that is also a good point. I was trying to see where that list is. You may be able to help me with that, Jennifer.
In the personnel policy, it just says that we would have a pre-employment drug testing requirement that must be passed post-offer before an employee starts their first day of work.
But that's a good point. We would need a paragraph in there that says, if they test positive, are we going to say that if they test positive for any controlled substance, then they're not going to be hired?
Well,
All offers of employment are conditional upon passing a drug and alcohol test.
How does it define controlled substance?
I think what it says is without hunting it in this manual, I think Clay, or Mr. Riddle, what it says is that anything that you have a prescription for that shows up in your system, you're okay.
So you can test positive for controlled
If
substance,
you've got
as
controlled
long as
substance.
you're prescribed.
Correct.
And that's a pretty big distinction. Just because I have a controlled substance in my system doesn't mean I'm doing it illegally.
Correct.
That's all.
So it would be an illegal. or unauthorized
Unprescribed.
substance.
Is that already in the policy?
I think I've read it in there.
Yes, I mean,
Yeah.
if it is, we don't have to change that then.
As long as it's all defined properly, that's all I'm getting at.
Then you have the option to present, if you test positive, you have to present your prescription from your medical doctor.
I think that's happened in the past several
Yes.
times.
And it has, and because there's some things that will create a false, there's certain prescription drugs that will create a false positive for illegal substances.
If that's in there, we can leave that alone, I think. That way each employee is tested when they first come to work. One way or another, you're right, mate, it's not gonna cost much, no more people that's hired. And the sheriff, y'all take care of y'all's yourself, so that really doesn't include y'all in this forward.
And I don't want to put words in the sheriff's mouth, but I'm understanding, I was told that your office may want to, if we end up doing business with this company that's present today, which will get it on another line item. But hang on, we'll just get into that. Hang on. The employee may not possess or use unauthorized prescription or over-the-counter drugs while on county property or while on duty for the county. An employee may not use prescription or over-the-counter drugs while on county property or while on duty for the county in a manner that other than is intended by the manufacturer or prescribed by a physician. An employee may use prescription and over-the-counter drugs in standard dosage or according to a physician's prescription if the use will not impair the employee's ability to do his or her job safely and effectively. An employee must keep prescription medication used at work in their original container. Said.
Yeah, that's the kind of stuff I was looking for.
I think that's good, and that's in there.
All right, so
If that's in there, then basically we're just dealing with what we need to do with CDL drivers then.
well, we've got a couple of things I think we need to add that I guess we need to put, I guess it needs to be
That
a
you
formal
mentioned.
motion.
Yeah. I bet.
Which would be to also, for an employee to also report to HR any accident or incident over and above their employer.
Should it be the employee's duty or should it be the supervisor's,
I think it's the employee's duty.
or both?
I think that certainly can't hurt that the supervisor sees to it, but this is actually the employees. This is a benefit or a detriment to them.
Because if the employee said he told the supervisor, the supervisor just forgot to report it.
I mean, it's gonna be the employees, well, it's their detriment if they come back and they can't get their workers' comp. So I think this really needs to be a responsibility of the employee, not to take anything away from the supervisor, because they probably also have the responsibility to report it and probably be sure that the employee does as well.
And that's, yeah. I don't know how you can say the manager, you don't have to do anything, but you're supposed to be managing employees.
True.
And I don't want them going over anybody's head on anything. That's not what I'm trying to get done here either. But
Well, I don't think that's the issue. I mean,
It's
I
just
think
to be
each
included in the-
individual employee is responsible for he's responsible to take care of his job. And if he's injured, he needs to report it. He can report it
if
to
he
your
or
office,
she-
just like he reports it to his supervisor. In my opinion.
Is there any problem with putting it in there, employee and supervisor report to HR?
Correct. And that's what it already says, they'll report to their supervisor. And that's what I'm saying. We need to add to that paragraph and says, to say the and to. And then as Mr. Riddle's saying, we can also add to it that says that over and above the employee, that the supervisor has a responsibility to move it forward to HR as well.
I mean, I feel like if there's, I feel like if it's any sort of employee issue, that's the whole reason of having an HR. If I'm supervising my people but not reporting significant issues that could affect the county to our HR or treasurer, I'm probably being neglectful.
And I don't disagree with that at all. I can tell you, I've
I
seen,
mean, whether it needs to be in there worded like that or not is different, but I'm just generally speaking,
I think we need to put it in there so that there's no question as to who does what. I've dealt with an issue where in times past where an employee got an injury, didn't think there was anything to it, didn't tell anybody. And then a few weeks down the road began having all these issues. And indeed, it was from that injury, and workers' comp denied the claim because they didn't make a report. So I think we have this in there. They report to their supervisor, they report to HR, and and the supervisor makes a report to HR. And that way we know we're covered. We know that employee's covered.
I'll put that in form of a motion, put it in there.
Second.
Linda's got that like you just said it. That's great. I'd say leave her trying to repeat something and confusing her more.
Do we want everything that we're gonna put in this thing under one motion?
I've been separate.
All right, so on that motion, for that paragraph to do with reporting incidents and injuries to HR, I've got a motion by Commissioner Langford and a second by Commissioner Darden. Any further discussion on that? All in favor? All voted for. All right, so then let's move on down here under where it says under the influence shall be defined in having a blood alcohol concentration of blank or more.
And that 0.01 is what, if you can't do 0, then the 0.01 be the least amount.
And that's what I'm telling you, I like 0, but it says, in this form, it says, this is from TAC, the county can choose anything from 0.01 to 0.08.
Put it in form of a motion to choose 0.01 for the county.
So I've got a motion by Commissioner Langford. I've got a second by Commissioner Murphy. All in favor? Or excuse me, is there any further discussion?
like you said,
You guys look like when you were that. All right, any further discussion? All in favor? All voted for.
Do you want it, because I went out 1,
Yes.
2 something?
Concentration, do you have a copy of this, Glenda?
I do.
Okay. Well, it'll just say
You just changed it
Concentration
to lower line.
0.01.
Okay.
well, it'll probably say blood alcohol concentrate. I mean, mean,
It does.
she's right, there's got to be a,
It says, actually it's spelled out, under the influence shall be defined as having a blood alcohol concentration of, and it will say 0.01 or more. So basically, we are saying zero, if it's 0.01 or more. And I think the last I see in this, on my notes, is on the last page, which is the leave of absence. And I think we discussed, says employees may request a personal leave of absence to a maximum of blank days. And I think we discussed 84, if that's
Yeah, did we vote on that just a minute ago?
on this.
On the alcohol? Okay. I was thinking ahead or behind, I was lost. I'm good, we're satisfied.
So was I.
Did we vote on?
Did we voted on the 0.01 or more, correct?
That's what I was asking. Okay.
In the pre-employment drug test, did we vote that?
Yes.
We did?
Oh, no.
No,
No,
we
we
didn't.
didn't. I didn't think we did either.
We
We
need to
skipped
vote.
over that.
We need to vote if we're gonna do pre-employment, reasonable suspicion, and post-accident.
All right, while we're on this, let's do this first. Leave of absence. Do we want to say the 84 days?
Yes.
Yes.
That keeps it, FMLA and leave of absence the same, is that form of motion?
Second.
All right, so I've got, on that last page, we have a motion by Commissioner Langford. I have a second by Commissioner Mayfield. Any discussion? All voted for. Okay, now let's back up. And before we do that, what we're talking about, is that going to be in this, or is that going to be in item, is that going to be in our,
We need to vote on it in,
Yeah.
yes,
Both.
it needs to be in both.
all right, so what we're discussing now would be, if we wish to do, obviously we know we have no choice on the random for CDL. So what we're going to talk about is if we're going to do all employee pre-employment drug testing. If we're going to do all post-accident and
Reasonable suspicion.
Suspicion.
and any reasonable suspicion of a person that's, that may be under the influence.
I make a motion that we do it that way.
Can we get all in the three motion, or all three of that?
One vote.
I'll second that.
All right. So I've got a motion by Commissioner Mayfield and a second by Commissioner Langford. Is there any discussion? All right. All in favor? All voted for.
Is that everything in the handbook to go through? I mean,
We're going to have a couple of things to discuss in the safety manual. So we may have covered it.
Yes. As a treasurer, is that everything that makes the drug testing clear to you? All right, that's all I'm worried about. Then we
Get
can,
this issue put to bed, Bob.
correct, thankfully.
All right, so then what we'll do is let's pass over item 12 and move to item 13, and we'll come back to 12. So under item 13, we have discussed and considered revised Montague County Safety Policy Manual and take necessary action. And a lot of that, gentlemen, is what we've already talked about. When we go to, well, we've got one here that I've spoken with the treasurer about that she'll fill in on page 4. On your sheet, you'll see that under designated employer representative, There's a blank there that will say Montague County. When we move to responsibilities, and again, I don't have page numbers, I apologize for that. Under responsibilities, you go to the next page, 2/3 of the way down, or actually middle of the way, it says supervisor/department. And if you go to the very bottom, the next to the last bullet point on that, what that's talking about is the duties of the drivers, which is CDL, drivers, supervisors. It says that it talks about the things that you will do and what that employee will have to do if you believe that they are under the influence, okay? And under that, next to the bottom bullet point, it says complete the supervisor's reasonable suspicion form. And Ms. Finolio and I spoke about that, and she will get a copy of one of those from TAC. It's basically going to be an ABC for you to fill in if you think your person is indeed under the influence or something. Okay? And we don't have that form with us this morning. Now, we go all the way back to the third from the last page at the bottom of the page where it says information/training. And that bottom bullet point, that bottom paragraph, it says all personnel responsible for supervising and managing CDL employees must attend at least 2 hours of training on alcohol and drug misuse symptoms and indicators used in making determinations for reasonable suspicion testing. And that's what we spoke about a few moments ago, where TAC is going to provide that to us virtually. Now, the other thing that they've advised Ms. Finolio that's not in here is that each CDL driver is going to be required to do 1 hour of training. And the way they've laid this out to Ms. Finolio is that when the supervisors do this 2 hours of virtual training, your CDL drivers will attend. They will stay for the first hour, and then that portion will be done. They'll leave, and the supervisors stay for the second hour. Now, you probably, if you've got some guys that have been here for a while, I'm going to guess that they've already had this hour training, but that can be researched and we'll find out. Then what will occur is if you hire a new CDL driver, they also have to have this hour's training. And so I think what we've got worked out with TAC is that we will simply get like a disc or a thumb drive that has that hour. And when this employee comes in and does his new employee orientation, he meets with the treasurer's office, he signs up for his insurance, he does all those things, he'll be given that media item to view and see and log in that he's done that hour and sign off. I think it's going to be a very simplest way to do it. But that needs to be added in this follow-up paragraph.
And the hour for each employee.
For each CDL employee. And that's the only thing, gentlemen, that I have found in this that I had any question on. Jennifer, anything else that you can think of?
You need the motion for the hour for each employee of training.
Yes, sir.
Go along with where the information and training is. And I'll put that for the motion.
So I've got a motion by Commissioner Langford. I've got a second by Commissioner Darden. Any additional discussion on that?
Could you repeat that motion?
It's
I know that one.
maybe,
I kind of lost that one.
get the simple, I'll make it, so however it be the simplest of, that each employee is required, each CDL employee is required 1 hour of, I guess it'd be alcohol and drug misuse training.
Correct.
And should it be an employee whose responsibility is utilizing their CDL?
That,
I mean,
well, I just.
I know that's what you intend. I'm just saying, I could have a CDL. But my job function's not driving trucks for the county.
Well, it's a good point. If we've got a CDL driver, as long as we don't say, okay, we're shorthanded, you hop in the truck.
And what are you gonna say?
That messed up my form of motion, but
Just say CDL drivers, what it covers.
Only one.
Okay, start all over,
I'm
Bob.
sorry I came today.
let me make sure we're here on the CDL drivers, though, that opens up Clay if he's got a CDL license, though.
And that's why I just think it ought to be more specific to whose employment function is driving vehicles that require a CDL for the county.
Which leads us to the second question of, if we've got a CDL driver and his current job is not driving that truck, is there any chance that we might put him in one? Because if so, we just need to let him do that out of training. It's not gonna hurt him.
I doubt there's probably any employees that not related to CDL that even have CDLs in, so.
And I agree that generally speaking will be the situation.
All right, all CDL drivers must receive 1 hour of alcohol and drug misuse training. That way it covers every CDL driver.
So, did we vote? I'm sorry, I lost track. All right, so we've got the motion by Commissioner Langford, we have a second by Commissioner Darden. Is there any further discussion?
I have, if Clay's playing devil's advocate, if you're gonna give them a flash drive to watch this training, they don't have computers for this employee to watch the training.
We're gonna handle that through their
Okay, okay,
organization.
okay, all right, just making sure.
Say an extra hour.
Yes.
Okay, all
And
right,
I'll send them to my office to do their paperwork, plan on being there for a little while.
okay, because we said send them with a flash drive, I thought, oh, no,
No,
what
they're
are
not.
gonna do with this flash drive? Okay, all right.
All right, so all in favor of the motion to do with the 1 hour training? All voted for. All right, now, let's back up to item 12. Well, where do that? Jennifer, anything else in those policies?
Not as long as y'all agree that those are our regular policies.
That's what we just did.
So,
All right, so we'll move to item 12.
They keep messing us up with facts.
Discuss and consider approving a contract with DATCS, which is Drug and Alcohol Testing Compliance Services, and take necessary action. And so I know that we've got Amy Hanley with that company here, so if you and Ms. Fenolia would like to address this. Contract.
Okay. What we have put in our contract,
You may have to come up here, I just barely hear you.
Clay, did you get a chance to read through that contract? That's okay? Okay. I'll look up here for you.
And you may come up too if you like.
Yes, please. Sure.
I'm old and I can't hear you.
Okay, so to get in compliance with the DOT regulations for our CDL and DOT regulated employees, we have to have a certified, DSHS certified lab that handles our drug and alcohol testing. We have to test 50% of our CDL employees annually and 10% for drugs and 10% for breath alcohol testing annually. The ATCS does all of that. And like I said, they've been very helpful through this process.
And they also will take care of our post-accident.
They will take care of our post-accident, our randoms, pre-employment, and reasonable suspicion.
And so if we can, let's talk about, because these guys are the ones that are faced with dealing with the random testing.
Okay.
So if you can explain how that will work.
Okay, so we have a program that we just pull the random employees. Since Montague County has 30 CDRs, around 30, you'll be placed into your own consortium pool, which means that only your employees will get pulled randomly. And then we'll send out the list of who needs to be tested. So whoever is the designated employee representative, they'll get a list of who needs to be tested. We schedule with them, like we can come out here, or you can come to us. It's probably easier if we come to you. And we can get them all tested on one day or multiple days. Generally, they have the whole quarter to test. I would recommend that once we notify you, we give them around 2 days to be tested, just to rule out any problems. But you do have a full quarter to get those random employees tested.
And so is there a difference in cost if you say it'd be easier for you to come here? Is there a difference in cost if you come here in lieu of them coming to you?
Well, so you do pay like an on-site collection fee, which would be $30 per hour if we come to you. It's not necessarily easier for us, but I think it might be easier for you. But you do have the option to send them to us. Our office is about 1 hour away from here, but you won't pay that $30 fee for the on-site collection.
Say that again.
If you send your employees to our office, you won't pay the $30 fee.
So the $30 is $30 per hour. You send somebody down here, the time you get here, go back, that's $60 plus hour while you're here too, or whatever, right?
Right, and any mileage fees.
Mileage, we got mileage on top of that.
Yeah, the 57 cents.
So a round trip's gonna cost, over $100 to $150 plus the testing then. So it'd be,
57 cents a mile, $57 up there plus $30 an hour, 90 there minimum, yeah, you're looking at $150,
if you're testing, I'm just thinking that if you're testing all of the random employees for that, do you test once a year? Or once a quarter?
Once a quarter.
Every quarter, and you test however many employees that be, coming down here might be wouldn't be such a big deal for the $150.
Right, because it would just be one time.
Yes, but let me step ahead, if we have a accident, the same rates would go in place if we asked you to come to us to test that employee.
Depending on how we get notified, so let's say if you schedule that testing 24 hours, it would still be that $30. But if it's an accident in the middle of the night and we get called out, it would be a $90 emergency fee.
Is that just the fee, or is that $90 an hour?
Per hour.
What about if it's during the middle of the day and you get called out, one emergency bill still out?
And
It's $50 an hour.
if it's unscheduled 24.
Well, it would probably be cheaper to come to y'all than if we had one employee that had an accident that would require a drug test. Because then you're not gonna have a 24-hour notice, it's gonna be right off the spur of the bat.
Is there a certain amount of time that you have from the time you have an accident to being tested?
It's recommended with the alcohol to get it done between 6 and 8 hours, but we should do it as soon as possible.
And in reading some of this, I came across some verbiage in there about emergency kits.
That just speaks to, let's say someone in the county gets trained to do collections, because we do that. We offer training if someone wants to perform collections here. We can give that person training, and we can give you kits, then the cups, testing devices, depending on what type of testing you're doing, DOT versus non-DOT, FedEx labels, the bag and everything, so you can test here yourself, one of your employees, and send it off yourself.
We send it to you.
It'll be sent to the lab. We'll give you a label, a FedEx label. All you do is put that label on that FedEx bag, and you drop it in the.
What I read was that those emergency kits are like $5 and something each.
Right.
And so what kind of training do we have to have for somebody to do that?
It'll be a collector training.
Okay.
And we can do it, I think we can do it virtually now, but it'll be good for 5 years.
And so what's the cost of that training and how long does it take?
I have to double check on the cost, and the amount of time. I have to check with our customer service team, but, I don't think it takes more than an hour.
Oh, God.
So we could have the sheriff take this training and he could do our collections and send them off.
That's true.
I think that's a no-brainer right there as far as if we have an accident and do, I don't really have a problem on a random drug test when they come down and check everybody, but on a accident, I think that'd be great right there.
Can we let the probation office do it?
Well, that's what I'm
Pre-employment, same way, right? We can collect.
As far as
Right.
collections,
Yeah.
yes.
I get, to my understanding, you could do it that way for even the random test. You know,
It's an emergency kit, so I thought it was only for
When
most
we
accidents.
were old.
The emergency kit, yeah, but you can do
Jack
it for non-regulated testing, you can't do that.
Sure.
Person.
So
Did you volunteer, Jack? Is that what everybody's
What
saying?
kind of HR do it?
Actually, we just need to research that just a little bit, because when I spoke with Cody Busby, he told me that he was willing to help us do whatever. The only thing we had was the company that he deals with as far as testing doesn't meet these same requirements. And so we can't do that. But if probation would help us with that, and we got, depending on what it costs to get somebody trained, can't think it's very high, it's only an hour training.
I have to double check on the time too, so, don't quote me on that. I have to check with them and then get back with each other.
I mean, we could get a couple of people lined up to do that.
That's why we did it on the rigs, every tool pusher was trained. And then
You might want your
we had
foreman
collection stuff out there.
you know,
And then if it's your foreman that has the accident, then,
then
his
somebody
foreman
else,
can do it.
yeah, that makes a lot of sense right
Yeah. Save a
there.
lot of money.
But that could be something that's worked out later, where all we've got to do
we
is
just need
decide,
to decide if we're gonna go with.
yeah. I think it's a big deal right there, being able to do that for people, especially with an accident or a pre-employment or something like that.
So let's talk about, because I know that the treasurer and I have spoken about this, let's talk about what we're really looking at for startup cost.
Okay, so if you were to do it for the DOT driver for the first quarter, it'll be $165. Just for that quarter, that includes the program enrollment fee, which is $45, and the consortium fee per quarter, which is $120. You do get a discount if you do it annually, and that would come up to $477. And that's for the whole year, including the $45 enrollment fee and a $432 consortium fee with a discount.
So that 477 is what it cost us a year just to be in the system.
Just to be compliant
Yes.
in the pool,
And
yes.
then the hourly rate and the drug testing kits, everything else is on top of that.
Right.
That's still.
Now, correct me if I'm wrong, what you were telling me the other day was that we would be required for every CDL driver, in order to meet compliance with the clearinghouse, we're gonna have to do an upfront test.
Yes.
Every CDL driver, not random, but everybody's gotta get a test.
Everybody,
Is that accurate?
it's considered a pre-employment because they've been out of the pool for more than 30 days.
Okay, so we've got 30,
Give or take between 30 and 40 probably CDL drivers.
So that spreadsheet that I gave y'all, that it's gonna be like a little over $1,100 plus the $475 for annual
Yeah.
enrollment.
and so that same testing fee applies even if we've got somebody trained to do our own collection.
Yes.
But we do save the testing fee is there, but if we do it ourselves, it saves us by the hour and mileage.
Correct. We'll collect and mail it off.
Yeah.
And then how does it work if we do this and then we've got an employee that comes up positive? How will that function?
In which situation?
Say that we do this and we do we test everybody up front for our clearinghouse.
Right.
Okay? And one of those people comes back as positive. What will happen after that? How?
Then it has to be reported to the clearinghouse. So we have a few options here. If you would like to keep this person in your, as an employee, they have the option to go through a substance abuse professional training, which would mean that they would go through so many weeks of counseling with this person. That's called a SAP, a substance abuse professional. They will also have to do a return to duty test, followed by follow-up testing. And that's if you choose to keep them. And it's in their best interest to do that program.
Sure.
Because it helps with their record too. Because every positive test shows up on their record through the clearinghouse.
So that positive employee, will that report go to HR? Will it go to the supervisor? Who will that go to?
To the designated employee representative.
Which is gonna be me.
Which would be the HR.
But what if it's medication driven?
Well, so anytime it's medication and they have a prescription for it, it doesn't come back as a positive result, it comes back as a negative result. And the only time it comes up as a positive is if it's a drug that can impair them at work, even if they have a prescription, the medical review officer will put a note that they need to do a physical or follow up with their doctor, just to make sure that they can perform their work duties while on this medication.
So that would be what we spoke earlier, where we would provide a job description.
Yes.
The doctor would have to look at that and say
Yes.
whether they could or could not perform that.
Do you have to have all your medications registered with y'all that you take?
No, that will go through
That
the
comes
medical review officer. We
Comes
don't,
afterward.
right, we don't have to know what medication they're taking. All they'll do is when we send it off to the lab and it comes up, the medical review officer will call that donor at the number that they provide. And they can provide prescriptions via text, a picture, through the pharmacy, or verbally over the phone after confirming information.
I think that's it.
And then it comes back negative, like I said, once they have a prescription.
I've got a question for the auditor. How do we pay for this? We'd have to have a line item for this set up, wouldn't we, Jennifer?
I believe it's the precinct 4 gravel line item. Isn't that what we decided, Clay?
You know what I've got in there, and it probably ain't too much.
I think we're getting out of putting that on precinct 3.
Yeah,
I think there would be, oh, there you go.
I don't have a problem with each precinct paying splitting this 4 ways and paying their own bill here. Unless you have but if you happen to have a CDL, say Clay's a CDL driver or CDL license, who's gonna pay for his?
But Clay is not holding a CDL position and would never have the opportunity to climb in a truck unless it was a disaster, and then we wouldn't care.
But he does,
I'm in a truck.
he does have to have a pre-employment or a drug screen though. With what we put in place, all CDL drivers have to have a drug screen.
All CDL drivers who are employed as CDL drivers have to have a drug screen by, if Clay's got a part-time job driving a truck, he's responsible for maintaining his, we're not employing him as a CDL driver.
Didn't we just do that?
Whoever he's driving for on the weekends is responsible for
It
his.
was all CDL.
I think it's all CDL, anybody with a CDL, so take the sheriff's office, if they've got somebody working for them with a CDL, I mean, I think with what we voted on, I think that any CDL driver employed by the county would be tested.
That's why I think that previous one, maybe I misunderstood. needs to be for the purpose of being a driver for the county, because if I got, y'all don't even know if I got a CDL or not.
Why
you
doesn't
will.
HR have that information, Clay?
I'm just telling you, what if I got it last weekend, you know?
You know, I think it should
I
be.
think it's gotta be your purpose of your employment.
Yes.
Or the possibility of, like I say, if we've got a CDL.
Yeah, if you got
driver-
another road hand that's,
I mean, if I've got,
Doesn't
if
drive,
one of
but-
my, if one of my clerks has a CDL, obviously, if she, under my office, she's not gonna have any function as CDL driver in the county.
She wouldn't have a function as a driver, but if I'm not mistaken, the way we passed that vote a while ago, she would require testing from the county just because she holds CDL.
You're exactly right.
I think that's the way we voted it a while ago. We can amend it to exclude the CDL license that do not drive a truck or drive for the county. We'd have to, or it's all going, that,
I agree.
I think all the road and bridge departments require a CDL license, and that is the only department that,
other than our part-timers, don't,
that's in the road and bridge department though.
yes.
Um,
Again, I don't have a problem with splitting it up 4 ways, whatever we have to pay out of that. If we exclude CDL drivers that could be at the sheriff's department that's non-using their CDL, we're gonna have to back up and amend that motion that we made.
And I agree, that's what, of course, that's what Clay was getting at originally.
Yeah. That's the way I understood the motion. It counted every CDL driver that Montague County has to have a drug test. Before we back up, Judge, I'm doing this deal here, going with this, the DATCS group.
Well, if you look in your packets, it's fairly lengthy. Mr. Riddle has reviewed all of it and agrees with its content. This would also require my signature.
It's gonna be split up. I get, what did you say is $1,100 and something Jennifer?
The $1,140-ish is for, to have, if we have 30 CDL employees that we do the pre-employment.
It goes by however many employees that, so it might vary. If I've got 4 CDL employees and Roy's got 5, it would cost him a little bit more. This, anybody else got a question? I'll make a motion for this thing.
Let me say, this brings us to where I was earlier. And I don't want to put words in the sheriff's mouth, but I understand that you discussed with the treasurer that the sheriff's office also wants to, I think right now you're doing business with an outside hospital outside the county. And I was told that you would want to be involved in this as a user with this company as well. Is that correct? So they would, of course, be doing the pre-employment tests, post-accident, et cetera, which they would take out of their budget.
Yeah, same thing. Their, whatever their cost is, comes out of their budget.
So the only cost question is the membership fee, basically, that we have to pay to, because, and then on top of that, we pay per each test. And I believe that's 400 and something, correct?
77 for the year. But just a
77 for the
consortium
year.
fee.
So if we paid that out of contract services and non-departmental, and then the testing actually comes out of the department and their operating.
All right, that's because everybody has to be a pre-employment test.
Yes.
You said non-departmental, the membership is non-departmental.
Yes.
And the testing is individual. Individual officers. I guess we got money in non-departmental today, that's 477. put that in form of motion, Judge, to go with, is that y'all's name, the Drug and Alcohol Testing Compliance Service?
Yes, it is.
Put that in form of motion for Montague County to go with Drug and Alcohol Testing Compliance Services.
Second. All right, so we've got a motion by Commissioner Langford, a second by Commissioner Darden. Any additional discussion?
Do I need to put how the payments are going to be made here in this motion? Okay.
No.
Got that, yeah.
And give the judge permission to sign.
And give the judge permission to sign all documents.
Any other discussion?
That's, to my understanding, that's Montague County, that includes the sheriff department, everybody.
All in favor? All voted for. Thank you. Now, motion.
And that was on number 13.
That was actually, I think, yes, ma'am, number 13.
And how did the motion read, Linda, for all CDL employees in Montague County?
Yes.
And it needs to exclude, does that need to be worded that non-participating?
CDL holders that are using their CDL license.
All CDL utilizing,
Also, CDL license holders who are being utilized.
For the purpose of employment.
you make a motion.
I put a form of motion.
See, I guess it supersedes it, but I'll second that. That could easily have the sheriff's office have a CDL driver.
And had no reason.
No reason to be drug tested like this.
All right, so an amended motion, we have the amended motion by Commissioner Darden and a second by Commissioner Langford. Any additional discussion? All in favor? All voting for. Well, anything else on this? All right, we'll move to item 14, which is discuss and consider approving replat in precinct 2, Flynn Stewart Lakeside subdivision, lot 14 and lot 15, and take necessary action.
That's a plat that they had redone, and it's a county road that showed that went through their property, and it's actually 100 foot from where it's at, but they had it redrew where the county road is, and it's always been, and I'm just trying to get cleared up for make that before the motion to accept that replat.
Second.
All right, so I've got a motion by Commissioner Mayfield, second by Commissioner Langford. Any discussion? All in favor? All voting for. Do I have, that's our last item, do I have a motion to adjourn?
Motion to adjourn.
Motion to adjourn by Commissioner Langford, second by Commissioner Darden, all in favor? All voting for. Thank you.